Hello everyone. Today I'm going to discuss with you the different sources of international law. See, sources of international law are the materials and processes out of which the rules and principles regulating the international personalities are developed. These rules are extracted and analyzed from the sources. According to Lawrence and Oppenheim, there is only one source of international law, and that is the consent of nation. But rarely considers customs and reasons as the main sources of international law. But as pointed out by Stark, there are like certain formal sources and material sources of international law too. So the material sources of international law, may be defined as the actual materials from which an international lawyer it determines the rules applicable to a given situation. And the term its source refers to methods or procedure by which international law is created. A distinction, it is made between the formal sources and the material sources of law. As pointed out by G. Fitzmaurice, they may also be described as respectively as direct and indirect, as proximate or immediate, and remote or ultimate. Material sources may also be described the origins of law, while the material, historical, or indirect sources it represent the stuff out of which the law is made. That is to say, they go to form the content of the law. The formal, legal, and direct sources consist of the acts or facts whereby this content is clothed with legal validity and obligatory forces. Okay, so there is like a distinction being made between the formal sources and the material sources of international law. But Article 38 1 of the Statute of the International Court of Justice, it is very much widely recognized as the most authoritative statement as to the sources of international law. And the law applicable in the ICJ, as per the Article 38 of the ICJ, there are 5 distinct sources of international law. They are the international conventions or treaties, international customs, general principles of law recognized by civilized nations, the judicial decisions and writings of the publicist, and also the reasons and equity. These are also the sources of international law. First and foremost, the from the above five sources, that is like the international conventions or treaties, international customs, general principles of law recognized by civilized nations, decisions of judicial or judicial decisions and writings of the publicist. The third source, that is general principles of law recognized by civilized nations, it was first mentioned in Article 38 of the Statute of the Permanent Court of International Justice. Okay, and then it was retained in Article 38 of the Statute of the ICJ. Okay, so these are like the sources of international law. So very first one is the international conventions or treaties. Treaties are also known by a variety of terms: conventions, agreements, pacts, general acts, charters, statutes, declarations, and covenants. Okay, so they are known by different names. In the modern period, international treaties are the most important source of international law. This is because the reason that states have found in this source a deliberate method by which to create binding international law. And Article 38 of the ICJ, it lists international conventions, whether it is general or particular, establishing rules expressly recognized by the contesting states as the first source of international law. And this very term, the conventions, is used in a general and also inclusive sense. Okay, and a convention may be general either because of the number of the parties to it or because of the character of its contents. It may be particular because of the limited number of the parties or because of the limited character of its subject matter. And whenever an international tribunal decides an international dispute, then its first endeavor, it is to find out whether there is an international treaty on the point. In case there is an international treaty, the decision of the court it is based upon the provisions of that treaty. So that's why international conventions play a very significant role under the international law. And according to Article 2 of the Vienna Convention on the Law of Treaties 1969, a treaty is an agreement whereby two or more states establish or seek to establish relationship between them governed by international law. But this definition is very narrow and it does not seem to be correct. And Schwarzenberger, he told that treaties are agreements between the subjects of international law, creating a binding obligation in international law. So this is the meaning of treaties. However, there are certain conditions, or you say that it would be wrong to say that the Vienna Convention it does not show its awareness to this fact. For Article 3 provides the fact that the present convention does not apply to international agreements concluded between states and other subjects of international law or between other subjects of international law, and it shall not affect the legal force of such agreements. So, these are like the importance of the how the treaties become an important source of international law. Now, this international treaties, you can divide them into two parts, two types. The first one is your lawmaking treaties, and the second one is your treaty contracts. Now, the lawmaking treaties is like it may be universal or general relevance, and the provision of lawmaking treaty are directly the source of international law. The development of lawmaking treaties it received an impetus from the middle of the 19th century. The main reason for this was that, in view of the changing circumstances, customs which were the most important source of international law were proving to be inadequate. Consequently, the states regarded it necessary and expedient to enter into the treaties, and thereby they established their relations in accordance with the changing times and circumstances. And this lawmaking treaties can also be divided into two types. One is your treaties enunciating rules of universal international law. For example, United Nations Charter is the best example of such type of a treaty which is of universal nature. Second, is of general principles, like you can see the international treaties which lay down general principles. And these treaties are entered into by a large number of countries. And example, you see 1958 Geneva Conventions on the Law of the Sea, Vienna Convention on the Law of Treaties 1969. They are the good examples of such types of treaties. And lawmaking treaties, it perform the same functions in the international field as legislation does in the state field. Lawmaking treaties are the means through which international law can be adopted to in accordance with the changing times and circumstances, and the rule of law among the states can be strengthened. So this is the first type of international treaties, that is your lawmaking treaties. Second type of international treaties or convention is treaty contracts. As compared to the lawmaking treaties, treaty contracts are entered between two or more states. The provision of such treaties, they are binding on the parties to the treaty. Such treaties also help, the formation of international law through the operation of the principles governing the development of customary rules. And this may happen when a similar rule is incorporated in a number of treaty contracts. Besides this, a treaty entered into by a few states is subsequently accepted by many other states as they enter into similar treaties. Finally, a treaty may be of a considerable evidentiary value as to the existence of a rule which is crystallized into law by an independent process of development. So you see that the first and foremost source of the international law is the international conventions or treaties, which may be divided into lawmaking treaties and treaty contracts. These lawmaking treaties can also be subdivided into universal treaties enunciating rules of universal international law, and secondly, treaties which lay down general principles. And the second division of international treaties are the treaty contracts which are entered into by two or more states or two or small number of countries. Now, you see here like lawmaking treaties as it is conducted between many states, and it creates general rules binding the states. They are also the main sources of international law since the basis of all international law is consent. Examples I have already told you: the Geneva Convention, you can say the Hague Convention of 1899 and 1907, the Geneva Protocol of 1925, the Genocide Convention of 1948. And treaty contracts, as it is like the contract between the two or more states, it deals with a special matter between contracting states. Example, you see Indo-Nepal Treaty on Trade and Transit, Indo-Nepal Treaty on Peace and Friendship. It creates particular law between the signatories, but it is also the source of universal rule. For example, Bryant-Kellogg Pact 1928. This is a treaty for the renunciation of war between the USA and France, and it became so attractive that other states also subscribed to its principle of non-use of force. So if more and more states consent to the rule of treaty contract, universal rule is established. Now, the second most important source of international law is customs. The Article 38(1) of the Statute of the International Court of Justice, it recognizes the international customs as a source of international law. The ICJ statute, it refers to the international customs as evidence of a general principles accepted as law. So you see, this is the second most important source of international law. There are various, this international custom. It has been regarded as one of the most prominent source of international law for a longer period of time. And it is the oldest and the original source of international law as well as of law in general. It is only in the mid-modern period, that the importance of customs it has suffered a setback. However, even today, it is regarded as one of the most important sources of international law. Customary rules of international law are the rules which have been developed in a long process of historical development. And Article 38, Clause B, Clause 1, Clause B of the Statute of the ICJ, it recognizes international customs as evidence of a general practice accepted as law. In order to understand the meaning of customs, it is also necessary, to understand the meaning of the word usage. The words custom and usage, they are often used to be synonymous. In fact, there is difference between the terms usage and custom, and they are not synonyms. Usage, it is in fact the early stage of custom. By usage, we mean that those habits which are often repeated by the states. And as pointed out by Stark, where a custom begins, usage ends. So you see, usage is an international habit which has yet not received the force of law. It represents the twilight stage of custom. Custom begins where the usage ends. So, there is a difference between these two terms. And usage is an international habit of action that has not yet received full legal attestation. It may be inconsistent and opposed to each other. But this may never be in the case with the custom. When the states in the international relation it start behaving in a particular way in certain circumstances, it is expected that in the similar circumstances they will behave in the same way. This is called the usage. But when the usage receives the general acceptance of recognition by the states in their relation with each other, there develops a conception that such a habit or behavior has become right as well as obligation of the state, and in this way the usage becomes the custom. And and it is always not necessary that usage should always precede a custom. It is also not necessary that usage must always become a custom. In certain cases a usage may become a custom, in certain other cases it may not become. Okay, and apart from this there are certain ingredients, elements of custom, the elements for making custom as international law. First and foremost, the duration of state practice. So there should be a long duration. The long duration is generally said to be an essential ingredient of a custom. This is particularly true of a custom in municipal law too. In municipal law, a custom is required to be ancient and immemorial. But this is not necessary for an international custom. Article 38 of the Statute of the ICJ, it directs the World Court to apply international custom as evidence of a general practice accepted as law. Emphasis is not given on a practice being repeated for a long duration. What is more important is the practice of states accepting the practice concerned as law. In the field of international law, customs have emerged in a short duration too. For example, custom relating to sovereignty over airspace and continental shelf. Next, you see the second, apart from duration, the second most important element of custom is uniformity and consistency in practice. So, the custom should also be uniform and consistent. In the asylum case, in that case, the ICJ observed that the rule invoked should be in accordance with the constant and uniform usage practiced by the states in question, and that this usage is the expression of a right appertaining to the state granting asylum and a duty incumbent on the territorial state. Okay, so it is very important that custom should be uniform and it should be consistent. So this is the second most important ingredient of custom, that it should be uniform and it should also be consistent. The third very element of custom as international law is that generality of practice. So although universality of practice is not necessary, the practice should have been generally observed or repeated by numerous states. So this is also one of the most important elements for making custom as international law. The fourth essential element of custom is your opinio juris et necessitatis. So that means acceptance of practice is law. And so this is the fourth, very essential element of custom to become an international law. And you see, these four elements make it like a custom as a source of international law. Apart from this, there are some views regarding the customary laws. Like, can customary law be significant in the present world? The first opinion is that the custom can't be significant today as source of international law because it is too clumsy and slow moving to accommodate the evolution of international law. Second opinion is that it is relevant in the present day also, as it is the dynamic process of law creation and more important than treaties since it is of universal application. So this is like the second most important source of international law. Moreover, you see there are various leading cases where you can see how international custom will be applied in international law. The importance of international customs. And these customary rules of international law have developed as a result of the diplomatic relations between the states, the practice of international organs, state laws, decisions of the state courts, and state military or administrative practices, and also the treaties between the states. And in this matter, there are a lot of important case laws where you can see that international custom has will be applied in international law. For example, the case of West Rand Central Gold Mining Company Limited versus Har. In this case, a test regarding the general recognition of custom was let down, and the court ruled that for a valid international custom, it is necessary that it should be proved by satisfactory evidence that the custom is of such nature that it has received the general consent of the states, and no civilized state shall oppose it. So this is one of the case. Another very case of concerning the military and paramilitary activities in and against Nicaragua, the World Court observed that if a state acts in a way prima facie incompatible with a recognized rule but defends its conduct by appealing to exceptions or justifications contained within the rule itself, then whether or not the state's conduct is in fact justiciable on that basis, the significance of that attitude is to confirm rather than to weaken the rule. Another case is like right to passage over the Indian territory case, Portugal versus India. In this case also the ICJ pointed out that when in regard to any matter or practice, two states follow it repeatedly for a long time, it becomes a binding customary law. So these are the two most important, you can say, the sources of international law. And there are various numerous other cases how the custom has become an important sources of international law. And there has been a marked decline in the importance of custom as a source of international law in modern times. This is mainly due to the fact that the process of the development of a new custom is very slow. However, in modern times also, the development of new custom is possible, and at times customs have developed with accelerated speed. Principles relating to sovereignty over airspace and continental shelf are also glaring examples. So, but in the view of the accelerated speed of the changes in international community, custom has now become an inadequate means for bringing about the changes and development of international law. So these are the uh, two most important sources of international